that there are conditions attached to it by the government, if nothing else, on how it is to be used, or accounts have to be submitted back, then that becomes something that the public can also access. So, but if you, for example, distribute diaries without specifying that this diary must only be used for official work, then that doesn't make you a public authority. But if you, for example, suppose you give land, you might not want accounts of the land, but you specify that this land is being given on the condition that it must be used for non-commercial purposes. Then the public has the right to know what you are doing. So I would define substantial not in terms of percentage, but if the input from public funds or public resources is such that there is answerability involved, then the public has right.
I can cite an example in this respect. We have the Cochin International Airport, which is being conducted by a society headed by the Chief Minister. Chief Minister is the Governing Council Chairman. But the government has only 26% share in it. The rest of the shares are held by private people. So we issued an order that this is a public authority, saying that this is headed by the Chief Minister, a number of ministers are in the Governing Council, the Chief Executive is appointed by the government, things like that. And the society went to the High Court under Article 226, but the High Court agreed with this. I just
Shall we? Sorry.
There's a synergy actually between 2F and 2H. Information says relating to any private body which can be accessed. So that point was made. That even if it is not accessed but can be accessed, it's covered. Now if you look at information, right to information, one is 2F which says can be accessed, and if you look at J, held by, that is to say the information is already with, the private information is already with the public body. But the second part, under the control of. Right. So if you take the Minimum Wages Act analogy, I can ask for the minimum wages of workers in, say, Reliance Industries, because the minimum wages inspector under the Minimum Wages Act has the power, he has the control of that information, he can collect it. Education cases likewise. So held by means the public authority has got it. Under the control of means it is potentially available. So that ties in with information.
But the problem, Mr. Gonsalves, is that if somebody goes and asks the labor officer that please tell me in village X if Ram Hari Yadav is paying minimum wage to his servants in the field, right, should be now under the Right to Information Act that labor officer would visit the village, inspect the farm lands of Ram Hari Yadav and interview the individual workers and find out whether how much they are getting and then decide whether they are getting and then give this information. Is that the postulate?
See, that's why
the law applies. The labor law doesn't make a distinction between the Reliance Industries and an individual. Anybody who employs a labor has to pay the minimum wages.
Sure, but this RTI Act makes a distinction.
No, but private body, what is a private body? I mean, that has not been defined here. An individual can be a private body.
I don't know, this legally...
Why can't he be? Let's suppose, or a small farm, supposing an individual runs a small farm in a village and employs 3 workers. So if I go and ask, should that be collected? See, the question is that using it selectively for activities which are in absolutely admittedly in a public realm, such as a school or a college, is a private hospital or a private airport, is totally understood. Information must be accessed. But if you stress the definition, as you very rightly said in your opening remarks, there is no aspect of any citizen's life which is not controlled or governed by any law. India has got probably 10,000 laws. Even as we are sitting here and discussing, we might be either violating or following certain laws.
We must be violating.
So therefore, let us not really unduly stretch the limits which will not be unenforceable. So therefore, leave it to the judgment of individual commissions to, like the Delhi Airport Authority was declared by the CIC to be a public authority, though they were claiming that they are not. So wherever it is
No, but I think there are two separate debates, Mr. Saab. One is that is restricted to a corporate body or registered, or does it also apply to individuals?
Actually, you could swing both ways. It might be individuals, it might be corporate. You could swing both ways. But I want to say that, the power exists. In a particular case, whether you want to exercise it for a single person not being paid minimum wage is a separate issue. But the power exists to get it. Very clearly, I think. Now let's say, for example, Commonwealth Games. DIAL is the public body. Or forget DIAL, let's say MCD is the public body. MCD engaged about 5,000 workers, paid less than the minimum wage. Would I have the right to come to the commission and say, these workers are getting less than the minimum wage, I want the information about the wages being paid?
Sure.
So you're looking more at the practicality aspect. It's a large number versus a single person and so on. But the power exists, I feel. Whether you exercise it or not, the power to get this information from private bodies.
It will need to be ruled upon by the apex court sometime to really fix the contours of this part of the definition of 2F. And till then there would be individual interpretations.
Yeah, but I must say that actually Supreme Court judgments, good judgments, come from very determined judgments of the commissioners. If you as a commissioner give a very well-reasoned, hard-hitting order, let's say it goes against the trend, it bucks the trend. One commissioner is holding that private bodies are covered, 99 are saying no. But a very well-reasoned, hard-hitting order, you can never tell, you may make history.
Yeah, that's right.
Supreme Court judges only take what you give them. Your logic, your reasoning, your everything, they take that.
I'm not disputing the fact, disputing the fact that in selected cases, the contour should be, or the scope should be enlarged in public interest.
Right.
But let us not really fall into a trap that if we say that any information which a public authority can access under any law, there is no information about any individual in India which cannot be accessed under one law or the other. So in that case, then the right to information will be the only exercise which the country would be doing nothing else. I mean, only finding about individuals.
There is a flip side to the whole thing.
Yeah.
No, please carry on.
Yes, please. Sit up.
Yeah, it is particular whether private individual is a body, a corporate this and that is subject to debate, because citizen is now defined as not just an individual, but it can also be a corporate body. So there are any number of decisions. So I am not getting into that. Now, I said flip side. Today, almost all the commissions are saddled with a huge backlog, maybe about 7,000 here, 10,000 there, 20,000 there with public authorities. Today, if we start declaring private bodies within courts, bringing them under the public equivalent to public authority because of some definitions, the number may go up to I don't know what, and we may be running something like today, the pendency in the Madras High Court, the CJ says it's about 1,20,000 cases. How many years I don't know. But tomorrow, maybe the Information Commissions will have something like 1,20,000 cases. It's only a flip side, I said.
Unless, and we've actually helped them file applications under the Right to Information Act to the BSCS, to the DERC, and I think that the whole definition, this debate is extremely important, because increasingly we are seeing that unless there is clarity and there is a clear signal that the Commission is taking a view that these bodies are covered under the RTI Act, we're not going to get information. And I think there might be, of course, the flip side that you mentioned and, Mr. Mishra also talked about. But I think on the whole, when a decision is taken and if there are any rules that are sort of decided on, it does need to be kept in mind that it's extremely important for people to be able to access information in today's context.
I have one. Yeah, I have just to react to this. Now, where the public function is being carried out by a private body, I'm not talking about individual. Now, with the government's policy shifting towards public-private partnership, private-public partnership, things like that, there is bound to be a lot of private agencies coming into the public sector, public service sector. Now, where public function is being performed, say for example electricity, is a public function. You cannot say this is a private agency. Water supply, I think today Delhi Milk Supply Union is also a private body. It has been given to a private body. You cannot say, nobody can say that this is a private body, therefore no question can be asked under the RTI. And
But it
we are,
no,
it cannot be. Anyway, this is my view. where the question now arises, as Mr. Mishra was pointing out, one individual engages 3 persons as his servants in the farm. Now, because he is also covered under the Minimum Wages Act, should the labor inspector go find out and get the information, come, and then the distinction is only between that. It's a very, very thin margin. It's a private individual, but not a body. If Desu, I don't know what it is now being called, that is doing a public function, this is very much to be declared as treated equivalent to public authority and coming under RTA.
Yeah, ma'am, the commissions are already declared. In the opinion of the commissions, the distribution companies or whatever,
I agree.
disinvested companies, they are in existence at the largest of the government. I mean, the substantial funding part absolutely thoroughly applies to this body. They would not be there unless the government had decided to break DESU and hand over the function to BSCS. So BSCS is a public authority for the purpose of distribution of electricity.
In fact, in the morning or earlier, Shekhar had made a comment that citizens would do things. Here is something that I want to place before most of you. Most public functions and with government finance is being given to private companies. These are public authorities as defined in the Act.
Yes.
There is no doubt about it.
Absolutely.
In fact, Haldia of Planning Commission also admitted this.
In the meeting.
I suggested to Mr. Haldia, I said, why don't you put it when you are divesting anything that these bodies accept that they are public authorities as far as the RTA Act is concerned, but that the government is unwilling to do. And I think unless civil society moves to push the government into saying whenever you are divesting some of these things and you are controlling, mind you, a lot of these bodies, the government continues to have control, continues to have 50% of the money or investment. But this is a big design. They are all saying, and the moment any commission does order that they are public authorities, they go to court. This is again that, therefore, with the courts, I think this would get destroyed. My suggestion is civil society must move on this. This is extremely important, as you are saying. But I think the way to move this is to try and get the government to agree that whenever they divest any of these things, or whenever they continue to have a stake, which is true in most cases, they should do this with a contracted agreement and a term in the contract saying that these will be public authorities under the RTA.
Does the work that all the right to information clauses are applicable to you. It's very simple. So anything can be accessed. It is very clearly written. So we had pursued this too, that all repair boards repairs the contractor cannot say that I won't cooperate with anything, or whatever the information is asked under the right to information about that contractor, the government assesses or directly the contractor has to also repair. So this is the clause which is there in the agreement with the private contractor.
10 आदमी से ज्यादा वर्कर रखते हो तो मजदूर कमिश्नर के पास से उसको वो लेना पड़ता है लाइसेंस, और जो कामदार काम करता है उसका स्टेट इंश्योरेंस जो कॉर्पोरेशन